This may not entirely make sense. I've had a hell of a long day. Um, I finally had a chance to go over the PDF from Westlaw of all the different elements, variables of the 36.06, the harassment, or no, the obstruction and retaliation that Mr. Springer and Mr. Nguyen are. Well, they've gone to the magistrate. I don't think they actually have formal charges yet, but it's probably going to go to an indictment. If I remember correctly, it needs an indictment. Everything's blurred together. Very sorry. Okay, so the first one is INRI BM. The retaliation statute's purpose is not limited to a reduction in the number of killings, but also to encourage a certain class of citizens to perform vital duties without fear of retaliation. The statute does not require the threatened retaliatory harm be imminent, nor does it require the actor actually intend to carry out the threat. This is Meyer v. State. Comments can be evaluated as threat-based, not just the language used, but also the context within which they are uttered, even veiled threats. I want to do the veiled threats first. So this is one, Hudspeth v. State. On September 27, 1998, appellant returned to the residence after he'd been drinking alcohol and been arguing with Mary, who, according to the testimony, either called the sheriff's office or told her neighbor to call. When the deputies arrived and arrested appellant again, Mary testified he made the following statements. When I get out, you've had it. I will take care of you and that damn bitch across the street when I get out of jail, and for calling the law, you will pay. It was her opinion that these statements meant appellant intended to come back and do bodily harm to me or to get even with me for calling the law on him again. The defense did not present any evidence at trial. We agree with the appellant's counsel's conclusion that under the applicable standards of Jackson v. Virginia, etc., 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 this evidence is legally and factually sufficient to support the conviction. Then there's this one. The August 1988 letter states in part, you made me look like a damn fool in 1985, and I am not never going to forget that. Complainant. I am not going to never forget in my whole lifetime that complainant that I will always and forever love to the end of time had me put away for 10 effing long years in TDC. Thank you very much. I love you for it. I don't give a damn no more what I do. You did what you had to do. Now I am sorry that I am going to do what I want to do for now on, and what that is, I will only know. You fuck me over real bad. Sorry for the F-bomb. And like hell if I am ever, or like hell if I am going to forget that. A rational trier of fact could conclude that the above language, thanking complainant for putting him away in prison and telling complainant that he loves her for it, is sarcastic, and that the true intent of the letter is to threaten the complainant. So there we go. We hold the evidence is sufficient for a rational trier of fact to conclude that the complainant intentionally or knowingly threatened to harm complainant by an unlawful act in retaliation for her part in having him incarcerated. Yes. Yes. Courts aren't stupid. They understand sarcasm. I want to do this one next. Ms. Guziak told Webb's actions were dangerous and unacceptable. She felt the children should leave the room, so she told them to go sit in the waiting room. She then told Webb and his wife that she was required under law to report the incident to CPS. Webb replied, "You better not. If you do, I'm going to start an all-out war with you and you'll be sorry." Ms. Guziak testified that she feared for her life because Webb had used the phrase "go to war" during past counseling sessions in the context of violence. Ms. Guziak left the room, went to the business area to get help, and called 911. And that was sufficient. He tried to challenge it based on the free speech clause of the Texas and United States constitutions, and he failed. Nandin v. State lays out the various elements. These are the elements that you need to prove in order to convict someone of it in Texas. Number 1, the defendant. Number 2 is either intentionally or knowingly. Number 3 is harms or threatens to harm. Number 4 is another person. Number 5, by an unlawful act. Number 6 is either in retaliation for or on account of. Number 7 is the service of another or the status of another. 8, as a public servant, or B as something else that B, there's B, C, D, E. There's public servant, there's witness, there's et cetera, et cetera. So those are the 8 elements. And finally, in Texas, this is Doyle v. State. In Texas, the long-standing rule has been that a threat, though conditional, is unqualified if the accused had no right to require the condition. That's like, if you say, get out of the car or I'll shoot you. If it's your car and you're telling someone who's not privileged or whatever to be there, then maybe you're okay. That wouldn't be like considered a threat because you can tell them to get out of the car, right? But if you're a carjacker who got in the car and said that to the rightful owner of the vehicle, get out of the car or I'll kill you, then even though it's still a qualified threat, you don't have the right to tell the other person to get out of the car, so it's just straight up a threat. That's what they're saying there. Here, appellant had no right to publicity about his case and had no right to demand any particular action on the part of Judge Gibbs. The fact that the party threatened was not present when the threat was made is no defense. This rule is originally applied to other things. We see no reason not to apply the rule of threats under the retaliation statute, and etc. Now, what did we learn from this? We didn't learn near enough. That's what we learned from it. What I was hoping to learn was whether or not a third party's actions can be attributed to you if you're doing live stream, but no one has yet gotten me that information. Mr. Hemming told me on the phone that he would. I have not seen it yet. I'm not going to call Mr. Hemming a liar at this point. And who knows, maybe he's just busy. So one thing that I know other people were trying to latch on to was part D, thinking that somehow if it's written they have to give notice of it. What this is actually saying is that it's what prima facie evidence means is that it's evidence just on its face. It's what if you send someone a written demand and they choose to ignore it, then that shows the intent right there. Basically, at that point, the defendant would have to prove that that actually wasn't intent. It switches the burden of proof, basically. So this isn't saying that you have to do this. This is saying that if you send a person a written demand that they can't disclose the address or phone number, and they do it anyway, or they fail to remove it, or they repost it, or whatever. So if you send them the letter and then they fail to remove it or they repost it, then that's prima facie evidence. The state no longer has to prove those parts. The fact that you sent them the letter and they didn't pull it down means that basically the state doesn't have to prove the intent to cause harm or a threat of harm. Because the whole thing, like with these people, what they're saying is, oh, there's some people who posted addresses, but, you know, obviously they weren't trying to, you know, do anything. I mean, they weren't saying anything about it. Well, in that case, the state has to prove that they posted those addresses to cause harm or a threat of harm. If the state sends a letter saying you got to take this down, or if the individual whose name and address is posted up there sends the letter, a written demand to have it taken down, and it's not taken down, then the state no longer has to prove the intent. I know I keep going over it, but I'm tired, and I don't even know if I'm making sense right now. So when these cases are looking at it, they're looking at A1 or A2. This I can't see right now because my eyes are tired. This part or this part are the big elements. And then if someone is the poster. See, I don't know the evidence. I don't know the facts. And that's really holding me back. So my working theory is that they're somehow accountable because of what the chief said. I'm accepting what he said for some reason uncritically, because I have a feeling that he talked to a lawyer, a prosecutor, and the prosecutor said that's how they're able to do it. And again, I don't have access to a law library in Texas, so I'm kind of shooting blind here. I just don't have the evidence in front of me to know whether or not it's a good case. So I apologize for that. But without the evidence and without that statute saying that people can be held accountable for what they have on their stream in Texas, I just don't know. So I apologize for not being able to give you definites. I know some people would prefer a definite from someone who doesn't know, but sounds sure of themselves. Well, I don't think I'm ethically allowed to do that. I think I actually have to know what I'm talking about before I go out and say something is definite. Anyway, thank you very much for watching. Have a good night.